Hello, my name is Emma, and we usually talk about craft-related drama on here, but today we're going to talk about something a little bit different. In the past, I've talked a lot about copying dramas, and whenever we talk about copying, especially in relation to like knit and crochet patterns, there's always conversation and questions about what people's actual legal rights are. In the US, as far as I know, copyright covers the way that you write your patterns, like the actual word-for-word document, but it doesn't cover the actual design. And there's a lot more nuance than that, but I'm not going to get into it because that's not what this is about. Fashion copyright rules are very nebulous, and they are the reason that we see so many knockoffs of high-end and smaller designers, and there's always, you can't copyright a clothing shape, so there's lots of discussion there. In today's video, we are going to look at a really interesting, somewhat active legal situation that isn't getting very much press, but is a big deal in my opinion. I heard about this story from one of my fiber arts mutuals who has been involved in the case as a defendant. In short, the Smiley Company came after 700 small sellers on Etsy for allegedly infringing on the smiley face trademark. I'm going to talk to you about the legal scheme that they're using, and then I'll end the video with an interview with Beth talking about their experience going through the case like this. But before we do that, a very quick word from our sponsor. Since finishing grad school this year, I finally feel like I have time to get my finances under control. I've been trying to stop spending so much money on things that I don't really like so that I can spend more money on things that I do, like traveling to go see friends and buying yarn. And to help me with that is the sponsor of today's video, Rocket Money. Rocket Money is an all-in-one personal finance platform that helps you save more and spend less. I think it's really important to have a good picture of your finances, but the way that I organized all of my different accounts for a long time was that I literally had a note on my phone called "Where is my money?" And I always wanted to be a budget person, but I would get discouraged at how long it took to find the expenses, put the things in a spreadsheet, organize the categories, make charts, all of that. But Rocket Money has made budgeting so much easier. One of the things I really like is the categorization system with the drop-down menu, so I can easily see where all of my money is going and if that's lining up with my financial goals. As I mentioned before, I'm not the best at digital organization, so sometimes I end up paying for subscriptions for months longer than I realized just because I didn't notice a small charge on my account. Rocket Money securely identifies recurring charges and can cancel some of these subscriptions for you with just a tap. If you want to try it for yourself, download Rocket Money today and unlock more features like subscription cancellation assistant with premium. Go to rocketmoney.com/emmainthemoment or click the link in the description. Thank you again to Rocket Money for sponsoring this video, and let's get back into the story. So the Smiley Company's mission, according to their website, is to spread positivity through smiles, to make the world a happier, kinder place. Their website also says, throughout the last 5 decades, all our collaborations, partnerships, and experiences have laddered up to this ethos. And as we look ahead to the next 50 years and beyond, we're constantly finding ways to show people how to smile back at the world. We do this by continuing to encourage people to take the time to smile, because what's more inspiring and universal than a smile?
That's so silly.
It's so funny. And according to the current CEO of the company, who we'll talk a little bit more about later on, the smiley face is not simply a logo, it's a movement. It stands for defiant optimism, positive thinking, empathy, and doing good. Even if you don't know about the Smiley Company, like as a whole, you have almost certainly seen the iconic yellow and black smiley face logo somewhere. So, where did the smiley face come from? The smiley face logo, as we know it today, has a somewhat interesting history. According to most accounts, Harvey Ball is credited as the first creator of the logo. So in 1963, in Worcester, Massachusetts, Ball was commissioned by the State Mutual Life Assurance Company to create something to raise morale among the employees after a series of stressful mergers and acquisitions. So they asked him to make a little graphic design to make everyone feel better about like all the crazy stuff that was going on. Ball was paid $45 in 1963, which is now equivalent to $430 in 2022 money, which is when the article that I was reading this from said. He apparently did about 10 minutes of work on the commission, and then the company used this design to make posters, buttons, and signs with smiley faces on it. Neither Ball nor the insurance company tried to copyright the design at this point. And according to his son Charles, Harvey was not very money-driven. Apparently, he used to say, "Hey, I can only eat one steak at a time, drive one car at a time," which is cool and true and actually like a really nice perspective to have that I feel like you don't see a lot, and we're not gonna see with some of the other people how they approached the smiley face design. So then in the 1970s, brothers Bernard and Murray Spain saw a smiley button in the shop with this same design that Ball had made. They apparently knew that Ball was the original creator of this design, but they saw the potential in the logo for like marketing purposes. So they added their own slogan to this design that said, "Have a happy day." And then they copyrighted this logo and the phrase attached to it in 1971 and began producing their own items with this slogan and logo combination. In just over a year, they had sold 50 million buttons with this slogan on it. And the last, but certainly not least, inventor of the smiley face was Franklin Loufrani. Loufrani was working for a newspaper, François, at 19 years old and became tired of all of the bad news. So he decided he wanted to create a logo to spread positivity. He pitched this new column to the newspaper called Prenez le temps de sourire, or Take the Time to Smile, and he also added a smiley face logo to the column. In conjunction with this column, he also used this existing yellow smiley logo to highlight the good news and draw people's attention to it. Then he trademarked the smile and launched the Smiley Company. According to his son Nicholas, Franklin was motivated by the money he thought that he would be able to make on this design. You could say there was a political or social meaning behind what he did, but it was really a commercial act, Nicholas told The Hustle. He wanted to make money on it. So while Loufrani was aware that he was not the original creator of the logo, he claimed that the design is so basic that it can't really be credited to anyone, which I think is... He claimed the design is so basic that it can't really be credited to anyone, which I think is interesting considering how much money they make on owning the licensing to this design now. In this article from The Guardian, which is an interview with Nicholas, his son, they say, "To Loufrani, it matters not who was the first mover in the genesis of the smiley. The trademarking itself was tantamount to a creative act. He invented it in the sense that he invented the business model of making Smiley a brand. Apple, Adidas, Puma, Fred Perry, a lot of trademarks are very simple designs. It's not about who came up with the design, it's about who decided to build a business out of it, to make it popular, and to create values around it." So this business that he invented completely revolves around licensing the design. So licensing, in very basic terms, is essentially allowing other businesses to use your logo in exchange for a percentage of every sale. The Smiley Company now makes more than $130 million a year and is one of the top licensing companies in the whole world. Some of their biggest licensing deals right at the beginning that kind of got them started on this trajectory were Mars, the candy company. They put it on Bonitos, which is basically European M&Ms, Levi's Smiley Jeans, and then AGFA, a German film company, put its films in Smiley branded boxes. And then in addition to that, they also started off by doing a lot of journals, notebooks, pencils, office supplies, whatever. Following the Smiley Face's success in the 70s with its association with hippies, it found its place in rave culture in the 80s and 90s, due in large part to DJs like Danny Rampling, who bought a Smiley t-shirt and wore it to a festival in Ibiza, and the use of the logo on rave posters. After these decades of success, licensing deals were down in the 90s. That is until 1996, when Nicholas took over the business from his father and has continued to grow the company following in his father's footsteps. 1996, great year to be born. I wouldn't know about it, but... Here's a quick fire of my favorite random things that the company owns the licensing for. You can just look at their website and scroll through, and like on every page there's something crazy that you would not expect to be on there. But here are a few of my favorites. Disposable diapers, shoe polish, trash can, a telephone, like a landline, life jacket, essential oils, and my favorite is this $2,000 computer kiosk. Okay, quick pause for definitions. All of these definitions are from the US Patent and Trademark Office website. I'm not a trademark expert, so please feel free to chime in with any of your expertise below, or if there are any points you want to clarify or add about any of this. There are 3 terms that I want to briefly define before we move on: trademark, copyright, and intellectual property. A trademark is a word, phrase, design, or combination that identifies your goods or services, distinguishes them from the goods or services of others, and indicates the source of your goods and services. So the example they have listed of a trademark is Coca-Cola for soft drinks. So Coca-Cola, the name. A few other examples are brands like Apple or McDonald's, brand logos, specific product names or product shapes like iPods, Characters, kind of like mascots for a company that are associated with a brand like the Geico Gecko. Having a trademark basically just means that other people can't register that trademark and people can't use a trademark that's too similar to yours. The idea is obviously to protect things like logos, names, or identifying features of a brand from being ripped off and allowing other businesses to profit off of it. There are also fair use cases of trademark materials. The biggest one that comes to mind immediately for me is with parody. In season 2, episode 5 of Nathan For You, Nathan Fielder puts this idea to the test that fair use allows you to use trademarks and copyrighted material as long as you're making fun of them. In this episode, he renames a local coffee shop Dumb Starbucks as a way to generate interest and revenue and business to this location. Nathan took advantage of several rules that allowed him to operate this location for a few weeks. First, the location was a parody as it was making fun of the Starbucks brand. By calling the coffee shop Dumb Starbucks, the logo was modified enough to not technically violate the trademark. Secondly, trademark covers designs that are exact copies or really, really close imitations. So if any reasonable person can tell the difference between Dumb Starbucks and the real Starbucks, then it also does not violate the trademark. And thirdly, he was able to operate the location without going through the proper channels to set up a restaurant business by running it as an art gallery parody of a real Starbucks location. A sign on the window notified customers that Dumb Starbucks was running as an art gallery and said, "The coffee you're buying is considered the art." But that's for our lawyers to worry about. All you need to do is enjoy our delicious coffee. Next, copyright. Copyright is artistic, literary, or intellectually created works such as novels, music, movies, software code, photographs, and paintings that are original and exist in a tangible medium such as paper, canvas, film, or digital format. Examples of copyright are lyrics to songs, TV shows, movies, books, etc. Copyright serves as legal protection for your right to produce, distribute, and monetize. Copyright covers the content of the work, while trademark covers the branding associated with a brand or product. And finally, intellectual property or IP. Creations of the mind, creative works or ideas embodied in a form that can be shared or can enable others to recreate, emulate, or manufacture them. We'll talk a little bit more about intellectual property later on, but for now, let's move on and talk about the SAD scheme, which stands for Schedule A Defendants schemes. The defendants, aka the people being sued in a SAD scheme, are all listed on a separate Schedule A form, which is then sealed, meaning that the defendants are not initially notified that they are a part of this lawsuit and are being sued. I'll go over this all in a lot more detail throughout the video, and we'll try to break it down in multiple ways so that we can all understand what's going on, but I just want to get that brief summary out of the way first. This form of litigation is a tactic that is commonly used by rights owners, aka the people who hold the trademark for something, to sue a lot of smaller defendants at once at very low cost to them. I was talking to my friend Greg about this whole thing, and he pointed out that there are some similarities between these schemes and the idea of ransomware, due to the low barrier to entry and potential possibility to allegedly extort victims. Very, very basically, ransomware is malware, bad software that is designed with the intent to lock down a device and make it unusable. This is called encryption. So basically, a bad guy tricks you into downloading something onto your computer. When you open the bad software, it encrypts your device. This basically means your device is locked and you can't access anything on it. Then once this happens, the bad guy says, they send you a little message that says, "Hey, give me Bitcoin and I'll unlock your computer for you." And in a lot of cases, people end up just making this payment, the ransom, in order to get access to their device again, because it's worth this amount of money to avoid the inconvenience that it would be to go about unlocking their device in any other way or going through any sort of legal channels. Oh my God, the lighting on my face is making me look so washed out right now. The reason I bring this up is because there are laws in place that prevent ransomware, and I think we can all agree that this is bad. Holding someone's property for ransom is bad. One attorney who filed over 100 Schedule A defendants cases in 2022 was asked about the filings, and they said that these lawsuits allowed them to easily shut down any infringing listings and counterfeits, and then said, The strategy is more effective than the whack-a-mole game where you're sending takedown notices to the platforms. So they're basically admitting to this being a really easy way to just like strike down a lot of notices and get a little bit of money back as damages for these listings. So in this particular case that I'm talking about here, the Brickle IP group is representing the Smiley Company to sue Etsy, eBay, and RedBubble sellers over their use of the word smiley in their product descriptions. So big law firm represents Smiley Company, who sues a bunch of Etsy, eBay, RedBubble sellers who are all small businesses over using something that is allegedly infringing on their trademark. We'll be focusing mostly on the Etsy case here. There's really not much research being done about these kinds of schemes, but the leading researcher in the field is someone named Eric Goldman. He released a draft of a paper called A Sad New Category of Abusive Intellectual Property Litigation. When asked about these sad schemes in an interview, Goldman said, "I saw so many places where the procedures and outcomes just didn't comport with the law as I understood it. And I couldn't understand how that kept replicating. It wasn't like a one-off mistake. It was a systemic sequence of errors that the courts were producing. And when I give the presentation on my paper, the audiences are shocked." So Goldman coined this term SAD scheme, which, like I've mentioned, stands for Schedule A Defendant Scheme, because most of these cases put the defendants in a Schedule A form that is separate from the complaint, and then they seal the Schedule A form, which basically just means the defendants don't know they're being sued because they don't receive any sort of official notice. The SAD scheme finds legal loopholes and weak spots in the federal rules of civil procedure, judicial deference to IP rights owners, and online marketplaces' desire to reduce their liability exposure. So these large corporations, aka the rights owners, essentially exploit these holes in the system to extract settlements from online vendors without satisfying basic procedural safeguards like serving the complaint and establishing personal jurisdiction over defendants. So, in short, they request these big settlements from small businesses or people who don't have sufficient funds or time to cover legal expenses, and then these defendants just settle out of court because it's easier for them to pay off the big company to tell them to go away than it is to pay legal fees and maybe get the case dropped. Interestingly, these SAD schemes are very popular in 2 states. The one I want to talk about a little bit is the Court of Northern Illinois. According to a Bloomberg Law report, this district had received 817 Schedule A filings in 2022, which was a 900% increase from 2013 when the first Schedule A case was filed. In Goldman's paper, he talks a little bit about why it happens so much there. His first answer is because it succeeds. The cases go through, the defendants pay the settlement, and the big corporations get their damages. But that doesn't really explain why there's so much success there. But part of the way that this works is that the defendants are not given a chance to defend themselves, either because they don't know about it, they can't afford it, or a myriad of other reasons. So it's just the corporation coming to the court and saying, please help us, these people are counterfeiting our design, and then the court looks at it and goes, sounds good, they are, yet you deserve money. Interestingly, the judge for the U.S. District Court for the Northern District of Illinois is Martha M. Packold. Judge Packold served as a law clerk under Judges A. Raymond Randolph in 2002, J. Bybee in 2003, and Clarence Thomas in 2004. She also served in various counsel and associate positions in the State Department, and then in 2018, Donald Trump nominated Packold to the Northern Illinois District Court. There was a bit of legal back and forth before the nomination was confirmed in August of 2019. She has been in this position since, but then was also, interestingly, on a list of Trump's potential Supreme Court nominees in 2020. So this is who we're dealing with here. Packold also makes filing these SAD cases really, really easy for corporations by providing a template form literally on her website for rights owners to fill out. This obviously makes it a lot easier for them to file and win the cases because they know what information she's looking for and the exact format to submit it in. It's pretty much just like a plug and play template. And as my friend Greg said when I was talking to him about this, these cases are filed in a state that allows it with a court that encourages it. Goldman also outlines that there are 3 reasons how the legal system allows for this kind of scheme to continue. Number 1 is that IP has really strict liability laws to protect the rights holders or the rights owners. So the laws tend to really favor the side of the people who own the trademarks. Another reason why this succeeds so often is that this scheme can happen mostly or completely ex parte, which means only one party present. Basically, the judges are accepting the claims of the rights owner without allowing for any rebuttal of having the defendants there to defend themselves with legal counsel. And then the third reason why this has so much success is because online marketplaces like Etsy, RedBubble, and eBay tend to respond very swiftly and fully to the temporary restraining order that is set at the beginning of this scheme. And now we'll go into detail about all of the steps of how this plays out. But that's a big reason, is that these online marketplaces would prefer to just shut down shops than to go through and really see if the claims are legitimate or not. In August of 2023, Goldman made a statement to the US Patent and Trademark Office. He said, "As the USPTO knows, every IP policy creates errors. Some infringement will be under-enforced, and some enforcements will target non-infringing behavior or even be abusive. Knowing this inevitability, every IP policy must anticipate the possibility of rights owner over/misenforcement and incorporate appropriate substantive and procedural protection substantive. That's a hard sentence to say. And incorporate appropriate substantive and procedural protections for victims of such over-enforcements. This is especially important with respect to anti-counterfeiting and anti-piracy initiatives, given how often IP owners mischaracterize legally permissible activity as counterfeiting or piracy. It is impossible to discuss the current state or future strategies of anti-counterfeiting. It is impossible to discuss the current state or future strategies of anti-counterfeiting and anti-piracy enforcement without addressing the phenomenon of rights owners enumerating IP defendants on sealed Schedule A's, a phenomenon I call the SAD scheme." Then he attaches a link to his paper so that they can read this. The SAD scheme is a prime example of how rights owners are currently misusing existing anti-counterfeiting and anti-piracy rules. Until the SAD scheme is appropriately restricted, we will increasingly see rights owners prefer it over more traditional IP enforcement techniques. This means the SAD scheme threatens to replace most current and future anti-counterfeiting/anti-piracy tactics. Accordingly, any discussion about these efforts must account for the SAD scheme and its capacity for abuse. I encourage the USPTO to take stock of the SAD scheme's prevalence and impact. In particular, the USPTO can help generate more public data about it and improve public visibility to the scheme. So Goldman's paper also outlines how the SAD scheme works by breaking it down into 8 steps. In the following portion, I'm going to be using the terms that Goldman uses in his paper and weaving in some segments of the interview that I did with Beth, who was involved in the lawsuit. In this situation, the Smiley Company is the rights owner, as in they own the rights to the Smiley trademark, and the defendants are the online marketplace sellers. We'll mostly be talking about the Etsy sellers here. I didn't realize, but I somehow did not introduce Beth at all in our call. So this is Beth, who I'm talking to. This is their Instagram, and here are some of the things that they do. We talk about it a little bit more. I interviewed them for about an hour, but just with the flow of the video and everything, I couldn't include all of the clips of us talking, but I'm going to release that as my Patreon podcast, bonus video episode for the month. So that should be live by the time you're watching this video. Can you just start by telling me a little bit about yourself, what your art account is like, how you got into textile art, and just what you're doing?
Okay, so I've been, selling textile art since I was 16, so for 10 years. Mainly I'm now a multidisciplinary artist, a textile artist, fiber artist, everything, fashion designer. I mainly work with living textiles and biomaterials, as well as knitwear and crochet, but I've been selling bits and pieces online since I was probably about 16, just to supplement. But my Etsy's always been my lower end items, so just hats, coasters, little bags, stickers, prints. I mean, I started off, it was just crochet pieces, and then it kind of progressed to basically anything that I was making which wasn't super in line with my studio practice.
So step 1 of the scheme is that the company files a complaint with a caption referencing defendants listed on a Schedule A. So basically they have 2 separate documents, this formal legal complaint that has, the one in this case is about 30 pages long, and then on a separate form, there is a list of all of the potentially infringing products on Etsy. This one is also about 30 pages long, but it's just the name of the shop, the link to the shop, and the link to the product. Often these complaints will be very vague with no specifics so that they can be used to target multiple defendants at a time. Next, they will file this Schedule A defendant list separately from the complaint, which I kind of already mentioned, and then ask the judge to seal it. So basically, the judge sealing the Schedule A list means that anybody whose name is on the list won't find out about it and they won't be notified. Goldman mentions that there may be legitimate reasons why rights owners might want to seal a defendant list. Most commonly, this is to prevent counterfeiters who would then go to destroy their evidence if they found out they were being sued. So in these cases where there's malicious intent that the defendants are being sued for, by alerting them to their involvement in the case, they might be able to hide, destroy, move any evidence of what they were doing. But in general, by having this list sealed, aka kept a secret, the defendants don't even know they're being sued yet. In step 3, Goldman says the rights owner requests an ex parte temporary restraining order, or TRO, against the defendant's alleged infringing behavior. In most cases, a TRO is granted when a party can argue that it will suffer immediate irreparable injury unless the order is issued. And ex parte basically just means that the court is acting on behalf of only one of the parties involved. In this case, that party is the rights owner. So in the Etsy case, the court was set up to act on the behalf of the Smiley Company without first contacting these 700 Etsy sellers that they had been accused of infringing on IP. So this temporary restraining order sets up what Goldman categorizes as step 4 of the process, which is that the rights owner, Smiley Company in this case, submits a request to the online marketplace, Etsy, to ask for the platform to take down the allegedly infringing material. So these online marketplaces do tend to honor the TRO request because it's easier for them to do that to avoid as much liability as possible. And in a lot of cases, the implementation of this TRO legally only covers the single infringing listing. However, the online marketplaces often freeze all of the defendants' activities and just close down their shops. I'm kind of just speculating here, but I think it's because it's just easier to do that for, let's say, 700 defendants than it is to go through and find the specific listings that the rights owner is alleging is infringing and take that down. Because, again, just speculating, but if there is malicious intent, these defendants might just upload another product to their shop. There's really a wide range of people selling on online marketplaces, and many of them, if not most, rely really heavily on access to income in their shops. This marketplace freeze, as it's called, means that the defendant can no longer sell or list any items, and it also usually means that they can no longer access any of the money in their account. Goldman refers to this as creating severe or even fatal cash flow problems for the defendants. This is another reason why a lot of these defendants are unable to seek legal counsel, because especially if they are relying on the income from their shops, all of a sudden they also don't have any income coming in. Goldman then points out that at this point in the proceedings, we're on step 6 out of 8, the complaint is sealed. So the defendants first find out about the lawsuit usually only when their access to their online marketplace account is frozen. Will you tell us a little bit about how you first got notified about the lawsuit?
So the first notification I got on the link, it was like, your Etsy account has been suspended because legal action has been taken against you. And it was this link of a Dropbox of like tons of legal documents in it, and I was like, oh crap. I was like, oh, looks like a scam, because I've never ever been contacted by like Etsy legal or anything. If I've had any problems in the shop with like my shop before, it's always like come through like the main like Etsy webpage. I checked my Etsy and my Etsy was suspended, so I was like, oh my god, this is real. It was really like just super confusing. There were so many documents and I was just like, okay. And then the next day, I think it was like 24 hours later, I got an email from the lawyer's office with the same link accusing me and 700 other people of infringing on their client's copyright. I emailed them back and I was like, I'm really confused. I usually like super careful of everything I put on Etsy, because I've had like the DMCA takedowns, I think like once or twice before. Yeah, the first time it happened, it was I'd accidentally used a character's name from a TV show as like the name of the item, and I didn't really think to check it because I was like, oh, it's a really common name, like I doubt it's got a trademark. I was wrong. It was trademarked. So I learned my lesson then, and like since then I've been super careful, like double checking everything. And I had checked the item and I thought I was safe. So I emailed them being like, what the hell is going on? Didn't receive an email for like at least a week, and in the meantime that allowed me to like go into Reddit and like the Etsy subreddits, the legal subreddits, and find all these other people who are affected in the same case.
So at this point, the defendants receive an email from the online marketplace that they sell on, in Beth's case, Etsy. Their shop is closed and their income from the source has been cut off. This is when they usually first hear from the lawyers, from the rights owners, so the Smiley Company lawyers, and offer what Goldman refers to as a convenient settlement in order for them to just drop the case and give the shop back. This would involve then the defendant, in this case the small business owner, having to pay the Smiley Company a sum of money to get their shop back, and that is called settling. The settlement is usually quite high because the defendants are usually really desperate to get their shops back. And could you talk a little bit about, as this is progressing, what are they asking from you and what are they asking from, like, the lawyers? What are they asking from the other shop owners?
So we're all in this Discord, we're all sent emails, many of us sending multiple emails because we've sent like our first email as soon as we got it, because it says you need to reply to this within a certain amount of days. So my first email was very much like, okay, what's going on? I don't know why I've been included. Please, can you explain? The second email I sent, they hadn't replied to the first email. I think it was about 5 days after I sent the original email. They still hadn't replied. They replied to very few people in that time. So I sent the second email basically saying all the reasons why I didn't think my item had infringed on the copyright, and also like bringing up like weird inconsistencies in the actual documents.
You said some people in response to this ended up sending payments to them.
Yeah, so when people were getting like their replies, I got my first reply for them after I sent my second email. So I sent that email, and then I got a reply from the first email, and then they were like asking me for $2,500. And I was like, okay, so why have you replied to this first email right after I sent the second email saying, guys, like, this doesn't fly, like something's not making sense here. Well, some of the offers were crazy, like some were like over $10,000. They were just pulling numbers out their asses. But yeah, some people did settle because they wanted their shops back. They had the money to be able to pay it and settle, and they needed their shops back, so they paid.
At this point, the rights owner will often drop some defendants from the case, either who have not agreed to pay the settlement or for a variety of reasons. In Beth's experience, they noticed that the lawyers dropped all of the US defendants from the case, and Beth speculates that this was because they kind of want to make it as easy for themselves as possible. They don't want people to fight back. Goldman says that this strategic dismissal makes it so the case superficially appears to be moving forward. And then in the final step, once all of the previous steps have been completed, the remaining defendants generally are unable to appear in court. Again, Goldman lists a variety of reasons why they might not be able to, including but not limited to not being able to afford good legal representation, to the amount of money to settle just isn't enough to justify the time and money of going to court. The defendant may not be completely aware of the situation still. It's possible that they received this email in their inbox and either didn't respond because they thought it was spam or just didn't see it. And also, if the defendant did infringe on the IP, then they might not show up to court because they know that they'll lose. What happens then in most of these cases is that the court rules in favor of the rights owners, aka the corporation, because the defendants didn't show up to the hearing. The court then decides on the amount of damages that the rights owner is owed, and the defendants either pay that amount, or in some cases, the court rules that the online marketplace must turn over the remaining previously frozen funds in the seller's account to go towards damages, and that all goes to the corporation. In the Etsy case, the complaint, which was basically a legal document that outlines why the Smiley Company was suing these defendants, accuses the defendants of allegedly promoting, selling, reproducing, offering for sale, and distributing goods using counterfeits and confusingly similar imitations of Smiley's trademarks and copyrighted works within this district through various internet-based e-commerce stores They claim that the byproduct of the defendants' actions is the erosion and destruction of the goodwill associated with plaintiffs' trademarks and copyrights. They say the exponential growth of counterfeiting on the internet has created an environment that requires companies to expend significant time and money across a wide spectrum of efforts in order to protect both consumers and itself from the negative effects of confusion. They say that this is unfair competition, and there's also a line in there saying that the Smiley Company believes that some defendants have registered and or maintained their seller IDs for the sole purpose of engaging in illegal counterfeiting activities, which that's crazy to me. They then say that they are seeking damages for trademark counterfeiting and infringement and false designation of origin. So very briefly, why are some of these sellers not actually infringing on the rights? A lot of them just use the word Smiley as a descriptor in their product name. It's not the same IP as is covered by the Smiley Company IP trademark, so it's actually within fair use. In other cases, their product is modified enough that it's not easily confusable with the Smiley Company logo. And finally, in some of the cases, like in Beth's, the product that Beth was selling was not even covered by the Smiley Company trademark. So the trademark and their licensing agreement, it covers a lot of things. Like I mentioned some of those crazy products before, but they don't own the licensing to everything. They don't own everything. And Beth's item was actually not even covered by their trademark. You kind of all banded together and hired a lawyer. So tell me how you started, how you found him.
So I wasn't the person who found the lawyer or organized anything. There was different groups that got set off, like offshoots of the Discord. And then there was this group from Germany. When they'd been sent the documents, they'd accidentally had another document sent with all of these German shops' email addresses in. I mean, massive GDPR like data issue there. That's a whole other thing. But from that, they were able to like find each other, and they made this WhatsApp group separate from the Discord. It's been going on for about 10 days, I think. One of them came over to the Discord and was like, oh, guys, we've found this lawyer who's like a family friend of one of the people. But they're like, okay, we know this person. He's agreed to represent us as a group, and we're going to split whatever the hourly cost is. I was like, okay, so who is this lawyer? And they told us who the lawyer is. And I'm not going to give too many details because I don't know how much I am allowed to like share legally. But like he was well known, like he had documented cases, he'd won relatively big cases in IP law, and some of them he did like it seemed to be for like the good of like the IP law world in general, not just like taking money from clients. I was like, okay, I'm so done with this. I'm so anxious, like my stomach is a mess. I am not sleeping. I'm going to join this group. I'm going to split this cost and just hope something good comes from it. I think there was about 32 of us who agreed to like split the cost. So this landed up being about, I think it was about $50 each. Got in contact with him. He sends one email, tries to get hold of them on the phone. Couldn't get hold of them on the phone. So they scheduled like a meeting that gets cancelled very last moment and then rearranged for the next morning. And he was like, don't worry, guys, I'll just call them in the morning. I'll let you know. Like he wasn't concerned about it at all. So I went to sleep. That was the first night I had like a good night's sleep in like 10 days because I was like, I don't have to deal with them. He said, all correspondence comes through me. You guys don't need to email these lawyers. So I had a good night's sleep, and then I woke up with just like a really good feeling. And then I checked my phone and it was like 2 PM because I slept like a log. I checked my phone and I had like hundreds of like notifications from Discord. So I was like, oh crap, like what's happened? Like, is this good or bad? And it's like, no, it was all of the people who hadn't agreed to pay a settlement had been dismissed from the case. They didn't even land up having the telephone call with the lawyer we hired. It was all suddenly gone.
Are there any other updates on this since like the hearings and since, I mean, you did get your shop back.
I have my shop back. I have now closed it. I have moved to Shopify. Yeah. I think I was telling you earlier that I'd been planning to shut Etsy anyway, and this was just like the nail in the coffin where I was just like, I'm done. I'm leaving.
So tell me a little bit about what you're going to be selling on your Shopify, and then like where can people find you if they want to see your work, if they want to follow you, all of that stuff.
So my Shopify is going to be all parts of my practice. The first thing that's going to be sold is some just hand spun yarn because I'm obsessed with yarn. And then hopefully I'm going to be bringing some of my like living growable yarns there too, once I have that all sorted out, and because I'm currently applying for some funding and some awards and stuff for that. So yeah, there'll be yarns, there'll be probably garments, some accessories. Hoping that my living textiles will be on there soon. Not too sure. It's kind of difficult to figure out how to like send and post them.
Yeah.
But it'll be basically lots of different parts of my practice, lots of different price points. So hopefully there'll be bits for everyone. But that is going to be, let me just double check the website because I literally bought the domain yesterday. Okay, so it's beth-williams.co.uk. And then my social media, if you would like to follow me there, my Instagram is bxbeth, which is BEEXBeth. And then my TikTok is at knitmombeth.
Well, congratulations on the website launching. I'm excited to see it. I will list all of your stuff in the description as well so people can find you easily and buy your yarn and buy your living textiles and see what you make, because it's so cool. I am like so obsessed with all of your work. So I'm glad that we're like getting to talk. Well, thank you so much again for coming and talking about this and letting me know about this situation.
Everyone check your check your descriptions and names against all of the copyright trademarks and everything, because even if you think you're doing enough due diligence and you think you're protected by the fair use clauses in trademark law, there are still people who are gonna try and come after you anyway.
So a few concluding thoughts. Basically, as you have heard in the interview portion, the Etsy case was dropped, and recently, with the help of other people in that Discord group, the RedBubble case was just dismissed as well. Here are a few big takeaways from this story. First, this is a classic case of the law just not catching up with technology and where it's at and being able to adjust and find the loopholes and close them. Second, anyone can sue anyone, whether the allegations are true or not, and in that same vein, the legal system favors people with money and time. And if there's one thing that a big licensing company that's worth $500 million with an entire legal team has, it is time and money. But last and most importantly, this story reminds us of the power of collective action. The sellers did not have the resources to fight this alone, but because they banded together and organized, they were able to get the outcome that they desired and demand change. And finally, what can you do about this? If you sell in an online marketplace, take some time to check your listings and make sure that you don't have anything that might be potentially infringing on IP. It's hard to know what you don't know, and I'm no legal expert, so like really I can't help you with this. But protecting yourself, especially from copyright infringement, by not using character names or IP from movies, TV shows, is definitely a good place to start, if nothing else. And if you do find yourself in a situation like this, don't panic. There are options. I'm going to link an article written by Darren Heitner called Best Way to Defend Against the Brickell IP Group for Trademark Infringement or Copyright Infringement. This is a really specific list that outlines a lot of the steps that Beth and the other sellers ended up following to get their cases dropped. I'm not going to outline it all here because I'm not the expert and they say it better than I can, but the most important thing I want to leave you with is the reminder that you can fight back. It may seem daunting and scary. It may seem daunting and scary, but if you can organize and band together with people to find legal counsel, there is hope. You know, sets a great precedent that these cases can be dismissed. And we have good lawyers who are fighting for updates to the law to better serve everyone, like Eric Goldman, to thank for a lot of that. That's all I have to say. Thanks for watching this video. This was a crazy story to look into. Would love to hear your thoughts on this. Like, I would really like to have a discussion about this, and I have been emailing a little bit with Eric Goldman, who wrote the SAD scheme papers. So if you have any questions, depending on what happens here, I might make a follow-up video or something. I would be interested in looking more into this. If you liked the video, like it. If you want to see more videos like this, then subscribe to my channel. You can also go to my Patreon.
So if you even care about me.
If you even care. Oh. I'm trying to squish you.
And everybody, don't forget, If you like Emma and this stuff, do smash that like button, hit that subscribe button, ring that notification bell so you're notified every time Emma posts another video.
All right, that's all. Bye bye.